Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Jonathan Kappy.
Hi, I'm Ruth Aruliah.
Welcome to Haines Estates. You're listening to episode number 714. Today, we are going to be discussing electronic wills in Ontario. Different provinces have different ways that they handle electronic wills. And as the law develops, and we see the law develop in different ways, there's an acceleration of the development of the law as we got through the pandemic. And so Ruth and I, both think that this is a great topic to discuss at this point. So first of all, how you doing, Ruth?
I'm good, Kappy. How are you doing?
I'm good, thanks. I guess what we're going to talk about mainly is the limitations of electronic wills in Ontario, but I think we've got a great case to sort of kick off the discussion. Why don't you walk us through it?
Yeah, sure. So just a general breakdown. A holograph will in Ontario is a handwritten will where the witness is not required. The standard for a holographic will is set out in Section 6 and 7 of the Succession Law Reform Act. In Saskatchewan, however, a will was typed out and it was not printed and there were no witnesses. So we're going to kind of see a basic analysis of how the court approached that. In Haines v. Kuffner Estate, the King's Bench for Saskatchewan determined whether the proposed will was a valid testamentary document despite not being executed in complete compliance with the Wills Act, which is a Saskatchewan statute. A brief set of facts. Before passing, Kim Kuffner sent a message on her iPad to her two siblings with the title My Holographic Will, in which she named an executor and directions for her estate to be distributed. This individual had no previous will and no spouse or children. The executor applied to the court and there was no opposition, and she applied pursuant to Section 37 of the Act to declare this electronic message valid as Kim Kuffner's last will and testament. On an application for Section 37, the onus was on the party seeking to have the document admitted to probate. This onus was met when the applicant was filing for a substantial, complete, and clear evidence of the deceased's testamentary intentions relative to the document in question. So the singular question under Section 37 was whether a document is testamentary despite its non-compliance with the Act. And the two facets of this question is, number one, whether the document is testamentary in nature. So does it disclose the testator's true intent? And the second facet is whether the document represents the deceased's final wishes. So the court found that Kim's message directing how her estate was to be divided demonstrated that she intended this message on her iPad to be her true and last will and testament. So Kim began her message with My Holographic Will, and she named her person Reen Haines as her executor, and she left her house and contents to Ryan Haines and specified how her investments should be used and who should be her pet's guardian. As Kim's intentions were clear, it can be identified with sufficient clarity and certainty that her message was deemed to be her last will and testament of the deceased, pursuant to Section 37. There were some other facts to be considered, given that there was no opposition, as well as she was dying quickly. There was about 2 days when she was in the hospital and her siblings were coming to go see her. However, she passed away, and the communications and text messages said that she felt like this was going to be her last day, etc. And given the urgency of the situation, the court also took that into consideration. So, Kappy, could you kind of give us a walkthrough of how this compares to Ontario legislation? Would that suffice?
Yeah, well, listen, we're talking about Saskatchewan, and they've got different legislation. We have Section 21.1 that talks about substantial compliance. Okay. And so I suppose for the most part, when we're talking about electronic documents, they're not going to be witnesses. The reason I like what we're talking about today is it's a great thought experiment. Okay. So, in that particular case, we have an email that was sent. Okay. And I suppose there could have been two witnesses in the room with her when she typed her email. I suppose they could have typed their own names below her name typed to be witnesses or intending to be subscribing witnesses. So it doesn't necessarily have to be holograph. You could manufacture a fact pattern where there are two witnesses in the room who watch this person type their email and write their names or type their own names on their own behalf. So, but certainly, what we have to deal with in Ontario is the Electronic Commerce Act. Okay, because that act, and I don't profess to be an expert in that statute, but it talks about requirements in writing or requirements for writing and how the law will look at them if they are in electronic form. Okay. So to begin with, we talk about what is the definition of electronic in that statute. All right. And so an electronic includes created, recorded, transmitted, or stored in digital form or in any other intangible form by electronic, magnetic, or optical means. So we're talking about something that is on a machine in the cloud. I think what we would all recognize as something being electronic form. And then the statute goes on to talk about Section 4, information or document to which this act applies is not invalid or enforceable by reason only of it being in electronic form. And then Section 5 talks about the requirement where a document has to be in writing. And it says a legal requirement that information or document be in writing is satisfied by information or a document that is in electronic form if it is accessible so as to be usable for subsequent reference. And then it goes on to talk about what that means. But a will, regardless of whether it is holograph or a standard witnessed will, has to be in writing. That is one of the bare bones requirements. And so this Electronic Commerce Act is saying, well, if there is a document that is required to be in writing, it can be satisfied if it is in electronic form. Okay. Now, that being said, this statute does not apply to wills in Ontario. And there are two things. Number one, within Section 21.1 itself, it says subsection 1, dealing with substantial compliance, is subject to Section 31 of the Electronic Commerce Act. And that Section 31 says that this act, that Electronic Commerce Act, does not apply to the following documents: wills and codicils, trusts created by wills or codicils, powers of attorney, and then there's another couple of things on the list. So clearly, an electronic document does not comply with the requirements because it's not in writing. The Electronic Commerce Act will not allow the law or the court to regard an email that's in the cloud as being in writing, and therefore it can't comply. And it also specifically says that we are not going to grant substantial compliance with something that is purely electronic. But the thought experiment sort of goes on from there, okay? Because, all right, so we know that electronic wills are not allowed in Ontario. We even know that even under the laws of substantial compliance, a court cannot validate what is an electronic will. So, but what happened in that case that we just went through if the person who sent the email had printed out their email and put it in a drawer? Now, it's no longer electronic. It's no longer being stored in the cloud on a machine, on a magnetic tape or anything like that. And if you look at the way wills are drafted in the standard course nowadays, every lawyer has a computer. It originates in the cloud on a computer and eventually gets typed. So I think that if she had printed out that email, sent it off, printed off, left it on her desk, put it in a drawer, whatever, you're now no longer talking about an electronic document. What becomes even more interesting to think about is what happens if the recipient of that email had printed it off? Is it still an electronic document? Because it's now no longer in the cloud, it's printed. And then you'd have to deal with, okay, well, when could that person print it off in order for it no longer to be electronic? Can she print it off after death? Does the recipient have to print it off before death? All those kind of things, and what happens, and then, what is the date of the will? I assume the date of the will would have to be the date the email is sent, even though it's printed on a later date kind of thing. But there are ways to think about, electronic documents and when do they cease to be electronic so that they could fall within the jurisdiction of the court to validate it, even though it originates in electronic form, because quite honestly, nowadays, every will, unless you've got a pad of paper and a pen, every document starts off on a keyboard and a computer. So an interesting thought experiment. But I think that, if we get to jump to the end of this thing, is that you cannot have a purely electronic will, an email that's in the cloud, a Word document that's in the cloud or on a hard drive, that does not count as a will. It can't be validated as a will, number one, because the statute says that it's not in writing. And number two is because even under substantial compliance, the Electronic Commerce Act says that it won't apply. But with that being said, there are ways in Ontario to have an electronic will recognized. So Ruth, why don't you take us through some of that? And I think that Susanna Popovic-Montag in our office wrote a great blog about this. So if you want to read it in more detail, go check out her blog. But why don't you give us the summary of what she said?
Sure. So, her blog was basically, could electronic wills be probated in Ontario? And the overall understanding, as Kappy has laid out for us, is that they can't. However, there are exceptions. While electronic wills are not currently permitted in Ontario, it appears that you could probate an electronic will outside of Ontario and have that resealed in Ontario, such as the Haines case. If this was probated in Saskatchewan, we also know that wills can be probated in British Columbia, electronic wills. They could be brought as an application in Ontario and resealed here. Another way an electronic will could potentially be probated is, as I said, through resealing. So the British Columbia Electronic Commerce Act, actually,
Yeah.
we were talking about how that would apply. It generally does not, according to wills. According to the Supreme Court, an electronic will is deemed to be an original original electronic form if it is an electronic form which it was first being saved after being signed. So, Kappy, I have a question for you. In this situation, let's say that Haines Kuffner did probate their will in Saskatchewan, as they did. How would a person, let's say, wanting to probate that in Ontario, bring that forth?
Well, I think you're going to have to do it under the traditional resealing, but we do have sort of reciprocal agreements with other provinces, and we are going to recognize that if it is a valid testamentary document in another province, then it will be recognized in Ontario as a valid testamentary document. So even though we may not give probate to it, we may not think that it is a probatable will in Ontario. Once Saskatchewan decides that under the laws of Saskatchewan, if they are a resident of Saskatchewan and have assets in Saskatchewan and they get probate there, we will recognize it here should the person need, or should the estate trustee need to come to Ontario because, let's say, there are assets of that estate in Ontario as well. So listen, it's not like we are going to ignore another jurisdiction's rules. They can govern themselves in the way they want, and we will recognize their probate. But an Ontario will is not going to be granted probate by virtue of our legislation.
And you were saying,
yep. Yeah.
Oh, I was just that as more and more wills, et cetera, are being computed and through electronic devices, and for example, clouds are being used more and more as today's society moves more towards technology, how do you think Ontario will approach electronic wills in the future?
I mean, the reality is that life is becoming cloud-based. The question is, for a lot of things it works. Okay, the question becomes is formalities. I mean, the reason that we have all these formalities regarding the creation of wills, and Rodney Hall used to call it the ceremony of signing a will. It has to be in writing. You need witnesses. There's an order to things. Everyone has to be in the same room. Is because the law was trying to impart upon a testator the importance of making a will. What a big decision it is. How much thought needs to go into it. I mean, if you can send an email every other day to change the terms of your will, not only does it dilute the importance of the will, it becomes really hard to figure out what is the last will. I mean, you have, in order to track down what is your last will, do I have to check your phone? Do I have to find your old phones? See if there's something recorded on an Apple Note that you wrote down on your old phone. I mean, it becomes really hard to look for wills once things can be stored in the cloud. So I can see the argument for saying, if it's purely an electronic form, we're not going to allow it. It makes the probate process impossible. But I also see the value in people using that medium more often, or more comfortable with it, obviously are willing to use it for more than just business, for personal. And if you would send it in a letter, is it different than sending it by email? Well, maybe to the person who's sending it, it doesn't really matter. It's just the new way of doing it. Do you want it to impart legal obligations and legal rights by sending something by email rather than putting it on a piece of paper and signing it? So, I think there's value on both sides of the argument. I think that for the purpose of administration, it becomes overwhelmingly impossible to try to figure out what is a person's last will if every email they send could potentially be a will, right? Think about how many emails people send in a month. Do you have to, even if you have a signed will, do I need to go and get some computer program to search every email you've sent since that date of that will to figure out whether or not you potentially wrote an email that may contain a will that may be validated by a court? It's how could you possibly do that? So I can see the value in a court saying, you know what, if you want to do a will, there's a ceremony involved with that. At the very least, you have to print it out so it can be found. Otherwise, we're not going to do it. So there's the practicality of it too. I think that the court has to address.
Yeah, and in the Saskatchewan case, there were very fact-specific issues that were involved. So one was urgency because Kim was dying. And number two, she had the inability to write, so she had to use a stylist to type this out. And number three, there was no evidence that Kim was confused or suffering from any type of incapacity at the time of her drafting her email.
Yeah, listen, I think that case made it easier for the court to do it, right? Because we know that the email was sent so close to her death. We didn't have to deal with any other potential emails that she may have sent subsequent. But if I send an email, today in 2025 and I die in, 2050, whatever, that's a lot of emails that I've sent. That's a lot of emails that could potentially contain testamentary wishes. So it's a hard process. But anyways, I think that brings us sort of to the end of the discussion. I really enjoyed this one. It was a great thought experiment. But that concludes our podcast for today. We want to thank you for listening. I'm Jonathan Kappy.
I'm Ruth Aruliah.
Should you have any questions, please email us at info@hollandhull.com or contact us through the contact page of our website. Have a great day.
Thanks for listening.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hollandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe